Hello and welcome to this video on recent Supreme Court cases. In this video, we're going to look at two applications against the Secretary of State for the Home Department, and these are cases from 2023 and they're in the UK Supreme Court, and they are cases relating to immigration and the rules and requirements for a long-term visa. First, we're going to have a little look at the facts and the background for each of the cases. So the background for the first application. So the applicant A applied for leave to remain, and this application was with an application for a waiver of the fees for these applications. Now, A had leave to remain until the 14th of July 2017, and this first application was made in time. However, on the 18th of October 2017, the application for the waiver of fees was rejected, and they were given 10 days to pay the fee. Now, A was informed about this. Now, A paid all the application fees required, but did not pay the immigration health surcharge. And therefore, the application in total was rejected. And this application was made invalid on the 22nd of January 2018. Now, A made a new application on the 2nd of February 2018 with all the correct fees, including the immigration health surcharge. And this application was successful, and leave to remain was granted on the 5th of September 2019. Now, the main issue here was that A was considered potentially an overstayer, as their leave to remain ended in October 2017, and they only actually submitted a new application in February 2018. So there's that period of time where they had no application running, and they did not have leave to remain, and that's the issue in the case. The facts for the second case, this is the background for the other application, is that it's similar ideas to do with overstaying. So I had leave to remain, and I had made an application after leave to remain had expired, but within a grace period of 28 days. Now, this application was unsuccessful. I then made a second new application, and this was rejected, but when they appealed against this rejection of the second application, the appeal was successful, and so the application was successful. And so in a similar way, I was considered to not have leave to remain between the failure of his first application and the start of making his second application. Therefore, potentially he would be considered an overstayer. So the Supreme Court had to consider applications from 10 years of residency, and these were applications for indefinite leave to remain. Now, what the court was really considering was what was overstaying in terms of legislation. So for applicant A's case, what the court was looking at was whether Section 3C of the Immigration Act 1971 actually applied. Now, what Section 3C would have done it would have extended the leave to remain during a period of pending applications despite failing to pay the fees. So there was a question of whether the application was valid for this to apply. And then the other question for that case was what disregarded meant in paragraph 276B of the immigration rules, which was what would be disregarded in terms of the period of overstaying, or whether it be considered as lawful residence. And for the second case, the question for the court was the words of the previous application for paragraph 276B of the immigration rules, and what this meant, and whether the previous application for an appeal was the previous application linked to the appeal or any previous application. So this is what the court was considering in the case. So in terms of the Section 3C question, the court looked at the previous case of Mirza, which I've left a reference for at the end, and this suggested that Section 3C only applied where there was a valid application for leave to remain. Now, the application which applicant A made was with an application for a waiver of fees. Therefore, the application for leave to remain was linked to this application of fees. And as the application for a waiver of fees was rejected, this meant that actually the application for leave to remain was only conditionally valid on the condition that the fees were paid or the waiver was accepted. So after applicant A did not pay the fees, the application was invalid, and therefore Section 3C did not apply. So on the question of what disregarded meant for the immigration rules, the court decided that disregarded was to have the normal meaning of ignored. So if we look this in terms of the facts of the case, so what happened was A's leave to remain ended in October because Section 3C did not apply. And so there was actually a period of overstaying between the end of their leave to remain in October and them making a new application. Now the court decided that this period of overstaying did not break the lawful residence, so it meant that it didn't mean that they couldn't get leave to remain, but the question was whether it could be counted as lawful residence. Now the court said that the word disregarded, the normal interpretation of this word was to ignore, and therefore this period of overstaying, although it didn't break lawful residence, did not count as lawful residence for the case. The court decided, as to the question of what was meant by the term the previous application, that this refers to the application linked to the appeal, which ultimately actually granted the leave to remain. And so this does not refer to any application made during the period of overstaying. And the court decided this with one of the reasons being that otherwise it would be advantageous to make an application after the time had expired. So to evaluate this case, we should consider that the court actually noted during their judgment that the immigration rules are not very clear, and actually it'd be useful if they were clarified. But ultimately, this case provides some insight for practitioners and is useful for them understanding what the immigration rules mean. And on a wider note, it should be noted that the immigration health surcharge is actually going to increase this year, and it's going to increase quite dramatically. This will have a real effect on those seeking to get visas to stay in the UK. If you would like to find out some more about this, there's some references to the case which was mentioned during this case, the Mirza case, and there's a reference to it on the screen. And as always, if you have any further questions, feel free to contact me at TheLawGuide@outlook.com. Thank you for watching this video.